Hi, everybody. We're going to get started in a couple minutes. My name is Dan Kraus. We are also going to have Laura Hamden. She's not going to be presenting, but she will be assisting with this. She is our client care coordinator, and she'll be in the background just to let everyone know. She will be posting some questions and some, let's see, a planner. Um, and maybe asking some questions of you so that you can see the polling results of people who are um, in attendance. So we'll get going in about a minute, minute and a half. Hi, everybody. Okay, time to get started. 11:01 in Wisconsin time. And I just wanted to invite everybody to help yourself to refreshments. Just head on over to your refrigerator and pick something out if you like. Um, Grab a sandwich, get yourself comfortable. And today I'm going to be talking about Estate Planning 101. So first of all, I just wanted to once again say thank you for attending, and um, we will get going. Just to let you know, you should be able to see me and hear me talking, and also see the presentation. I'm giving a PowerPoint presentation. If you can't see the presentation, maybe you scroll up or to the side on your viewer there, and you should be able to see the slides. Okay, once again, I'm Dan Kraus. I work at a law office that I founded. I've been doing this for about 25 years. I do estate planning, I do estate administration, and that's about it. I don't do probate, or I'm sorry, I do probates, but I don't do things like uh, help people get out of jail or get divorced or do anything like that. This is all we do: estate planning, estate administration. I served in the Army. You can see there my picture there with the BCGs on. The BCGs is Army slang for birth control glasses. That's the glasses that they give you, and no one would go on a date with you if you're wearing them. That's why we call them BCGs. I did write a book, Estate Planning in Wisconsin. It is available right now on Amazon if you want to go out there and purchase it. I think it's about $15. It's not too long. It's very easy read. It's got a lot of good information about the basics of estate planning. It is not written for attorneys. It is written for normal people with normal vocabularies and normal understandings of this kind of stuff. So if you would like to learn more about this stuff, please feel free, grab the book. We will be having a second edition this year, probably. We'll add more information about nursing home planning. All right, so we at Krause Estate Planning and Elder Law Center do have many affiliations and awards, etc., memberships. These are a few of those, just showing that we are involved in the organizations that do estate planning and help people with that. What is estate planning? So estate planning is essentially putting your ducks in a row or getting things in order so that if you become incapacitated, someone is there that you've appointed to make sure that your stuff gets handled. And when you die, your stuff gets handed out and managed in the way that you want by the person or persons that you want to be managing that. So in formal terms, estate planning is to arrange for the management of one's affairs in case of incapacity and to arrange for the management and the transfer of one's assets after death. Some of the goals are to minimize taxes, fees, and administrative costs on asset transfer, and to maximize privacy and control to the family. Also to protect assets from nursing costs, creditors, and predators. Those outlaw in-laws. So to have a decent estate plan, the very minimum, the minimum that you need to have is a will or a will and a financial power of attorney and a healthcare power of attorney. Those three things, essential for estate planning. So let's talk about powers of attorney. Powers of attorney come in many different flavors, but the main categories are financial and healthcare powers of attorney. Healthcare powers of attorney is the most common estate planning tool. When people come to me and they say, well, we've got something, what they have usually is a healthcare power of attorney because somebody at the hospital or somebody at their clinic handed it to them before a surgery or a procedure or something and said, fill this out. We need you to do this before we're going to put you under. So many people have those hastily filled out, maybe not completely thought through, but it's better than nothing. It allows someone to make healthcare decisions for you if you are unable to make those decisions. So if you become incapacitated because of an accident, illness, or a long-term type of a situation like Alzheimer's, a power of attorney will allow somebody else, a healthcare power of attorney will allow somebody else to make those decisions, healthcare for you, up to and including pulling the plug. So it may be a decision about pulling the plug, but it can also be a simple everyday decision about who gets to visit you or who is allowed to come by, how often they're allowed to come by, where you're going to live, those things. All those things that have to do with your person, your body, are delegated to this healthcare agent. And specifically, it allows you to avoid guardianship. We'll talk a little bit about that in a bit. So then there's also the financial power of attorney, sometimes called a durable power of attorney, sometimes called a general power of attorney or general durable power of attorney. These are all documents that allow someone else, your agent, your chosen agent, to make your financial decisions for you. So they would be able to sign checks, usually also manage your bank accounts, sell your house, mortgage your house, give away your car, etc. But beware, With these powers of attorney, especially, and other documents here, I'm not so worried about the healthcare powers that you download from the internet. Those are generally okay, generally. But the financial powers of attorney that people download from the internet, very sketchy, usually not good in many areas. So beware, especially because state laws differ regarding these, and most downloaded forms are not adequate specifically for long-term care planning. So if a person has become incapacitated because of a sudden stroke or an accident or Alzheimer's, anything like that, if they don't have a power of attorney that has specific things in it, then their agent will not be able to save their assets from the spend down that's going to happen when they go into the nursing home or they go into assisted living. Without specific powers that are listed in the power of attorney, those powers of attorney can be just useless. And I've seen that all too many times. You must have a trustworthy agent. If you don't have anybody in your family that's trustworthy or that can manage assets, or that you would decide that you would want to leave your assets with them, you may be able to find another individual, like a professional that does this, or a trustee at the bank that might be a power of attorney for you. This also avoids guardianship. Now, let's talk a little bit about guardianship, because it is a boogeyman that's in the background. If you haven't done proper estate planning and you do become incapacitated, then the court is going to have to appoint somebody to make decisions for you. It's going to be somebody that you may not want. It's going to be a long and lengthy process in order to get that, and it's going to cost you. You pay for the guardianship that someone brings on your behalf. So if you don't plan, the state law is going to control, and this is a theme throughout. If you do not plan, the state law controls. If you don't know the state law, then you should learn it, or just make a plan. If you make a plan, then your plan controls and the state law is forgotten. So if you don't plan for incapacity, you've got to have a guardian appointed, and I just estimated the cost of that to be $6,000 and above. You have to have at least 2 attorneys, a GAL, and you pay for all of that. Then after that, the court supervises your financial and health care life. The guardian has to report to the court every year. They take a fee from your assets. They do all that stuff, and they get paid for it. And if you need nursing care, there's no way to do the type of planning that we would prefer to do, because the guardian is not allowed to do that. The guardian just has to keep paying and paying and paying and paying and paying for your care until you have nothing left. And then they would apply for Medicaid on your behalf. All right. So let's talk about wills. Wills, what are they? Well, first of all, let's talk about what they're not. They are not the state law. They're different than the state law. But if you don't have a will, then the state law is going to control the distribution of your assets and the appointment of whoever is going to be in charge of making sure that your assets are taken care of. Without a will, you're going to have probate proceedings in court. Coincidentally, with a will, you will also have probate proceedings in court. Anybody who's at least 18 years of age and is going to receive money from you, say a child or grandchild, niece, nephew, etc., if they're under the age of 18, when they hit 18, they will be able to get those assets, and it may not be pretty sight, 18-year-olds with assets. I'm sure they would love it, but be gone before you know it. And second marriage situation in Wisconsin, you got to be very careful. If you don't have a will, things get really messy. So dying without a will is called intestacy. It's not a disease. It's just a situation. Intestacy means no testament, no last will and testament, dying without a will. An example is old movie star James Dean. Well, he never got old. He died at the age of 24, but he was acting in movies in the 1950s. He was very successful, a rebel without a cause. He died without a will. Not surprising because he was 24. Not many 24-year-olds have a will, but not many 24-year-olds were as rich and famous as James Dean was at the time. His entire estate, including all of his licensing fees, etc., went to his father. Bad news is his father had abandoned him as a child. His mother had died when he was young. I think it was around 8 years old. Soon afterwards, his father just took him, gave him to his mother's sister, his aunt, who then raised him. He had a bad situation there and a bad relationship with his father. But because of intestacy, his father got everything and the aunt got nothing, and the father was rich just because he was the father of James Dean. So there are pitfalls of a will. Even though you avoid intestacy, you're not going to avoid the probate court, because a will is essentially a ticket to probate. It is only valid if you take the will into the probate court, and the probate court asks anybody, is there any objection? Is there any objection? You have to contact all the relatives and say, hey, there's this will, and you might want to object to it. So come on into the court. We're going to have a hearing to see whether anybody wants to object to the will. Then there's a lengthy probate. These days in Wisconsin, and probate averages over a year. They start hounding you from the court if you don't have it done in 18 months. But I've seen probates last for 10 years or more. There's no privacy in the probate court. Probate court is an open proceeding. What does that mean? It means if there's a hearing, anybody from the public can go and attend the hearing and just see what's going on. Also, it means that any documents that are filed with the court can just be requested and looked at, copied, taken home, printed in the paper, put on the internet, and it's all public. So there's no privacy for anything going through probate. So if your assets are involved with your estate, go through a will, go through the probate court, then the probate court and the public is going to have access to whatever it was that you owned, who is going to get it at your death, and what it's all spent on through the probate court. So that's no privacy for your loved ones. It invites predators. It puts a notice in the paper. It says we're having a probate proceeding, and then people can look in to see how much you had and whether or not they want to make a claim against your estate with the court. So let's talk a little bit about trust. So we've got a dichotomy here. On your left-hand side, there's a picture of the court. That's the probate court proceedings that are necessary if you have a will or if you have no plans at all. On the right-hand side is a picture of a woman. She's in her living room. She's doing paperwork at her table or at the desk there. And that is how things are done if you have a trust. You can do things at home and it's all private and at your convenience and not the court's. So let's talk about trusts. Revocable trusts, generally used as a will substitute. It allows all of your assets to pass to the next generation, to whoever you want to, without having a probate proceeding. It's all private. You don't have to publish any papers that says what you had in this world. You don't have to publish any papers that say who got everything, and it's all controlled by you. You set the trust up, and then the trustee follows it after you've passed away without court proceedings. Irrevocable trust. And if there's questions, we'll get to them at the end. I apologize. I didn't say that at the beginning. We will get to any questions at the end. So Hang on, I'll try to get to everyone's questions. Irrevocable trusts are not as commonly used, but they are still very common, but not as often as the revocable trust. Irrevocable trusts are usually used in order to preserve assets and sometimes for tax planning and avoidance. Let's see, we got some different types of irrevocable trusts, but planning is with irrevocable trust. Sometimes people create irrevocable trust during their lifetimes. Sometimes irrevocable trusts are created through their will or through their revocable trust after they're gone. Some examples are special needs trusts or irrevocable trusts that you can give to a disabled beneficiary that it won't knock them off of their government benefits. So if they're receiving SSI or Medicaid and they receive an inheritance, their benefits can disappear. But if they receive an inheritance through a special needs trust, then they will not lose their benefits as long as the trust is properly handled. You can also give your children trust if there's worries about your child's divorce or lawsuits or bankruptcy, so that they can have assets and after you've passed away without the worry about losing them. You can also create perpetual trusts to put vacation property in there so that you can put the cabin on the lake, and then you can also put some money in there, and then the money just creates money and perpetually pays the taxes and pays the upkeep on the family vacation property. You have to have a lot of money in order to seed that type of a trust for perpetual upkeep of the property. But if you have that kind of money, it's a nice idea, and then you can make it last for generations and generations. So many people ask me, well, if we have a will, we're going to have a probate. But if we do other things like put pay on death beneficiaries or have a joint owner of all of our accounts to have our children be the joint owner, then everything will pass without probate and we don't have to set up a living will or a living trust, a revocable trust. Well, that might work, but there's some downfalls. And here's just a little primer on which types of transfer methods work the best and which are the most secure. So the least secure on this list shows that you can see along the left-hand side of the slide, it says the things that can or cannot be done with each type of a transfer method. So will the method transfer property on your death? That's the top one. Will it avoid probate? Will it keep property for minors until they're a certain age? So will a person who is 15, will those assets be held for them until they're, say, 21 or 25 or maybe even 30? Yes, no, maybe. Will you, after you've engaged in this particular process, be able to change your assets? Will you be able to sell them without the other person's permission, let's say? Can you manage assets for yourself during incapacity using any of these methods? And can you protect your assets from others' debts? So somebody else might be a joint owner on your property. Do you have to worry about their debts as well as yours? Can your property be taken to pay their debts? So the only one in all of these columns that has yes all the way down is a living trust. It is the best way to transfer assets after a person has passed away. It's the most efficient and it's the least likely to fail. Let's talk a little bit about estate tax. Now, the estate tax used to be a really big boogeyman in the estate planning world, but now it's a very small boogeyman. It's a big boogeyman if you have lots and lots of assets, but you have to have over $13 million in assets this year to need to worry about the estate tax if you live in Wisconsin. Now, Wisconsin does not have its own estate tax. We only have to deal with the federal estate tax. Many states do have their own estate tax, and the limit is less than 13 million. So you have to check with an attorney in your state to know whether or not there's an estate tax in your future. Now, this 13 million is going to go down unless Congress acts. So if Congress does nothing, which it's very good at, then the estate tax exemption is going to go down to about half of this. So about 7 million in 2026. So between now and 2026, about a year and a half. And at that point, the estate tax exemption will go back down to about $7 million. We're not sure exactly because it all depends on the inflation rate. The cost of living increases. The estate tax in 2012 was 5 million and has been going up and up according to inflation. But then they overlaid this other law that gave us 12 million, and that's been going on now for a few years. But that law sunsets, and then we go back to the old law. So it's 5 million indexed for inflation. We estimate that it's going to be about $7 million when it kicks back in 2026. Okay, so another thing that we haven't really talked about very much is nursing home expense planning. Now, this is a much bigger boogeyman for people who are planning these days, bigger than the estate tax, because this hits a lot more people. If you don't know somebody who died penniless, broke because of nursing costs, then you are in the minority of people. So how do we do asset protection from nursing home costs? So if you reach 65, chances are better than 50-50 that you're going to spend some time in a long-term care facility. Now, sometime, it could be a very short time, but it could be a very long time. The average is actually over 2 years. So many seniors go broke every year because of nursing costs, nursing or assisted living. It's so expensive that very few people can pay for it out of their income. In fact, nobody on Social Security would be able to pay for it just with their Social Security. So how do you plan for this? Well, there's two ways to plan, and one is called pre-planning, and then there's crisis planning. Now, the pre-planning you can do if you are fairly healthy and you have assets that you can set aside. Then you can take those assets, you set them aside, and then in 5 years, they're no longer countable against you as far as applying for Medicaid. Now, Medicaid is the program that will pay for long-term care for the people who can't pay. So pre-planning is to avoid spending everything and putting some aside that's protected. Crisis planning is if a person needs nursing care or assisted living care immediately, and we don't have 5 years to put assets aside. In that case, we can save about half of the assets, and sometimes more, sometimes less. In this country, we have discrimination, unfortunately, but even the government discriminates. Now, the government doesn't discriminate according to, well, this is arguable, but under the law, the government does not discriminate according to race, religion, hair color, any sex, gender, whatever. It's illegal for that to happen, but the government can discriminate according to health care and what kind of health care you need. So if you have a disease in your old age, like cancer, you get treatment in the outpatient clinic and you get treatment in the hospital, and you have radiation and surgery, and it's a bad time for all involved, but at least you don't have to spend all of your money on this. It's going to be paid for through Medicare and a Medicare supplement insurance, most of it, because your care is in the hospital or outpatient. Now, if you're unlucky enough to have Alzheimer's disease, now the government's going to discriminate against you and say you cannot use Medicare to pay for that. You cannot use normal health insurance to pay for that. You need to dig in your pocket and pay out of your pocket until you're broke. Only then will the government step in with government health care. So that is the disease discrimination that we help clients to avoid. Here's the government plan. If you have the need for long-term care, what are you going to do? You're going to spend down. You have to spend everything except for $2,000. You can keep your home during your lifetime. You can keep one car and policies of burial insurance if you've prepaid for a funeral. All of those things you can keep. Everything else except for your household goods and furnishings, you have to expend on your care. Your 401ks, your IRAs, you have to cash in any cash value you have on life insurance. You have to take the gold bullion out of the safe. You have to spend everything except for this before you can qualify for Medicaid. And then if that's not bad enough, after you've passed away, if Medicaid has paid your bills, the state will come and take your house to repay Medicaid. So the house is only safe during your lifetime. The recovery process can come and get the house as well. So if you plan, though, you have to have a plan instead of the government's plan, and you have to write it down. You have to designate who's going to get what, and you have to start shifting your assets. And if you do that, if you do a good plan, you're going to keep the house for the kids, you're going to keep the farm for the kids, and you're going to keep most of your money for your security so that you could be in a nursing facility or a long-term care facility, assisted living, and still have money put away that your family has control of. So you don't have to be just completely broke. You can have Medicaid pay for your care and still have money if you do the proper planning. So one size does not fit all with estate planning. A lot of things depend on what your situation is and what your desires are and what state you live in. So online forms are standardized and they're not high quality. Sometimes you can pay hundreds of dollars for these online forms and you don't even know whether they're going to fit your situation. They're not customized, they're not customizable, and if they are customizable, you don't know how to customize them generally. It takes a lot of experience and education to know exactly how to do estate planning in different situations. So some examples of ways that your plan might not fit everybody else or everybody else's plan might not fit you. Do you have young beneficiaries? Do you wish for charities to benefit from your estate? Are you in a second marriage? Do you have children that are not your spouse's children? Do your spouse have children that are not your children? Those are really, really important situations. You need to do estate planning. Or do you have a traditional family? Are you a high net worth individual? Do you have millions of dollars to give to the next generation? Are you worried about those taxes? Are you solidly in the middle class so that you're comfortable now, but if you need nursing care, all bets are off? Do you have beneficiaries who are disabled? Children, nieces, nephews, grandchildren, somebody that you want to leave money to, but they're disabled? That needs special planning. Also, do you have children who I talk to all kinds of people. I don't know your situation, but sometimes people are estranged from their children. Some people haven't talked to their children in 20, 30 more years than that. What do you want to do about those children? Do you want to disinherit anyone? If you do, you need to do estate planning. You have to write it down. You have to have it properly witnessed, notarized, etc., so it's legal after you've passed. Say unmarried long-term couples might need to do estate planning. Otherwise, their significant other, if they're not officially married, is going to get pushed out of everything, even pushed out of the funeral, etc. Versus a single person. Older planners have different concerns than younger planners. Younger planners are usually worried about their small children. Older planners are usually worried about taxes or long-term care. Do you have a business? Do you have a farm? Or are you a state worker with large savings and pensions? Are you a military veteran? Sometimes veterans' benefits can be used to pay for some types of care, long-term care or other care. Are you in a marital property state? Wisconsin is one of 11 marital property states where property is treated differently if you're married. Most other states are not marital property states, so property defaults to individuals instead of the marriage. All right, so this all may be rather confusing, and it is called Estate Planning 101, and I've tried to cover a lot of the basics here, but this is not a college course, and it's not law school. So if you've been confused by this, you need estate planning. If you need estate planning, but you're not sure how to do it, what do? Well, you find an experienced guide, just as though you are going out into the forest or you're going to climb a mountain. You don't want to do it yourself if you're not experienced with that. If you are an experienced mountain climber, then you can go by yourself. Just the same, if you're an experienced estate planner, it might be okay if you did your own estate plan. Most people, though, should probably not try to do an estate plan by themselves, just because so many things are at risk if you do. If you would like us to help you, or if you have questions about estate planning for your particular situation, please give us a call or come online, schedule a meeting with Laura, and she'll get you set up with a meeting with me or one of our attorneys, and we may be able to help you. There's no cost generally for these meetings, unless we're talking about having help with someone who has passed away. Or if we're talking about giving you specific advice about long-term care, those meetings are sometimes charged for, but it doesn't cost you anything to call and find out. All right, so now I'm going to try to answer questions if you have any. I will start at the beginning. Let's see. Are attorneys moving to revocable or irrevocable trust rather than just wills? The answer is yes. Since the 1980s, revocable living trusts have really come into power, I guess, because people are just tired of probate. It was discovered that all 50 states allow you to avoid probate if you use a revocable living trust or an irrevocable trust, but the revocable living trusts are the ones that are most common. So yes, people do revocable living trusts in order to avoid probate and make things go smoother and more privately for their family. All right, let's see. Do I need a power of attorney if I'm married? That's a great question. And the answer is yes. If you have a joint account, generally you don't need a power of attorney to deal with that account. However, if your husband or wife or your significant other has an account with just their name on it, or a car was purchased with just their name on it, or if there's a credit card or anything with just their name on it, you'll need a power of attorney to deal with that, even though you're married to them. Now, even the Social Security Administration will require you to have a power of attorney in order to ask about your spouse's benefits, or to change your spouse's benefits, or to do anything else in your spouse's name only. Now, if you want to sell your house and it's in joint names, you do need a power of attorney because both people have to sign. And if one is unable to sign, the other one must have a power of attorney to allow both spouses to sign and sell that house. So the answer is yes. Just being married to someone does not make it so that they are automatically your power of attorney. Also, do not ever have only one choice. Well, there's very limited situations where you should only have one choice. If you're married, you've only got one choice. That's the only person that can deal with stuff. You should have a backup or two or three. You should have backups so that just in case something happens to your spouse, you're still covered. Okay, so there was a follow-up to that for health, a healthcare power of attorney. Yes, even though you're married, you do need a healthcare power of attorney. The state will not allow you to order to pull the plug or to do many things, to sign your spouse into a nursing home without that healthcare power of attorney, whether or not you're married to the person. So yes, you do have to have that. Where are we located? We have 3 offices: Brookfield, Wisconsin, which is near Milwaukee; Madison, Wisconsin, which is our capital in Wisconsin; and Oregon, Wisconsin, which is just south of Madison. It's a smaller town near Madison. Oh, I see. Laura had already typed in an answer to that. Let's see. Would I be interested in presenting to residents at a senior living facility in Oconomowoc? I would love to do that. Please contact Laura. Give us a call at the phone number there and say we want to have a presentation at a senior living facility. I'd be happy to come and arrange that. So yes, I'm happy to travel around, do these presentations. I like to get the word out. There's just not enough people that have enough information about this stuff in order to for everybody to have a good estate planning. That's what we want. Let's see. Can I quit claim a piece of land now to my children that has no mortgage and its own fire number? The answer is yes. You can quit claim any property that you want to your children. Quit claim is just essentially giving it to them. So a quit claim deed is just a deed where you say, I have this piece of property and I'm hereby giving it away. You can do that. There's problems, though, with doing that. There's an advantage to giving property to your children right away, and that is in 5 years, you can apply for Medicaid and they will not make you sell that property and spend it on your care, your long-term care. That's good. The bad part is, whatever you bought that property for, let's say in 1985, it was worth $70,000. Now it's worth $700,000. There's a lot of capital gains there. Between $70,000 and $700,000 is $630,000 of capital gains. Now, when your children go to sell that property, let's say after you die, they are going to have to pay tax on $630,000 or more of capital gains because you gave it to them during your lifetime. If you give it to them using a trust, you have several advantages. One is you eliminate the capital gains tax for them. Whereas, let's say in my example, $630,000 worth of capital gains tax is going to be over $70,000 of capital gains tax that your children will have to pay when they sell that property. $70,000. Now, if you had used a trust, you may have paid a couple of $1,000s to get that trust set up, but they are going to have zero capital gains when you die after they sell that property. So the question was, can we quit claim to our kids? The answer is yes, but there are issues. Tax is only one of them. There's other issues there. Let's see. Can we get the slides? No, we're not going to share the slides, but I can back up. Let's see, to the revocable trust slide. Okay, state tax, revocable trust. It's not a whole lot of information on that slide, but there are some advantages here. Okay, let's see. Oh, good. It looks like you're going to have the slides being sent to you. Okay, what happens to the trust if the company setting up the trust goes out of business? Great question. Nothing happens to the trust. So the trust is not associated with the firm that created it. So if you come to our firm and we do a trust for you, we get it set up, now it's yours. You can take it anywhere. You don't have to bring it to us when you want it to be amended or changed, etc. You can have it changed anywhere. We would love if you'd come back to us and use us as your attorneys, but it's not required. The trust is its own entity. It's just like a business. The lawyer that set up the business is not required for that business to operate. It's just the setup. So you can use us or another firm to set up your trust and then help you administer the trust, or have your family administer the trust after your death, or you could use a different firm. It's not required for the people that set up your trust to be around when the trust is needed. Okay, are the complimentary consultations in office, or can they be done virtually? Great question. We like people to come to the office, but if you can't make it, we'd love to meet with you virtually. So we can do either one. What is the typical cost to draw up an uncomplicated trust? So that's a great question. Our firm has a written price policy, and we quote prices depending on what it is that you need when we meet. But I can tell you that for a trust, the minimum I think that we're charging now is about $4,500, somewhere in there. I don't remember exactly, but the sky's the limit, because if you need different types of protection or different tax strategies, etc., we do trust packages that are upwards of $15,000. But we quote you a flat fee. If you don't see the value, you don't go with it. That's easy as that. We don't do a let's get started and we'll just charge you by the hour. We don't do that. We'll tell you exactly up front how much a trust plan or any other plan would cost. How do you move items into a trust? Depends on the item. If it's a piece of real estate, you just do a deed into the trust from whoever owns it now, transfer it to the trust. If it's automobile, you have to fill out the DMV forms to transfer from the owner to the trust. If it's a bank account, you have to take what's called a certification of trust into the bank, and you show it to the banker and say, I want my bank accounts to be changed into the name of the trust, and they'll do it that way. So depends on the asset. If it's just your furniture, your jewelry, etc., there's one sheet of paper that we have people sign that we say, we hereby declare that all of our stuff is now owned by the trust, and that's good enough for tangible personal property. Okay, I'm an elder orphan. No parents, no spouse, no children, no siblings. Do my deceased husband's relatives have any claims on my finances? This is a question that's specific to you. It's legal advice. I hesitate to give it to you, but this is a fairly easy one. No, unless there is some other thing that I'm not seeing here, unless there's a contract or some other arrangement that you had with your former spouses, or if there's a court order from the divorce, or if they all died, then no, there's no claim by your deceased husband relatives on your estate. But like I said, it may depend on the situation. Don't rely on that advice. I'm not your attorney. I have to say all these things. So you can't go and tell anybody, my attorney said that this is the case. But in general, probably pretty safe there. If you die intestate, do my cousins inherit or does it go to the state? That's a great question. In Wisconsin, if you live and reside in Wisconsin, you have to follow the laws of intestate succession. And there's a statute in Wisconsin, 853, I think it is, that is titled intestate succession. So if a person has the situation that you have, no parents, no spouse, no children ever, and no siblings, then everything that you have, if you die, would go to your grandparents, both sets of your grandparents. Now, I'm guessing that your grandparents are also gone, so now you have to go down the line from your grandparents. So you look at aunts and uncles. Any surviving aunts and uncles would get a share. Then you look at deceased aunts and uncles. Their children would get their share, and on down the line like that. So that's your first cousins once removed, first cousins twice removed. It will go to your first cousins in Wisconsin. However, it won't go to any charities that you might like because you didn't have a plan. It will not go to second cousins. Second cousins, what I mean by that is descendants of your great grandparents that are not first cousins or closer. So that would be second cousins. So descendants of your grandparents, first cousins. Descendants of your great grandparents, second cousins, they don't get anything. The state would get it before them. What's the average cost for will drafting? We don't do will drafting by itself. We do estate planning packages. So for us to do a will for you, you would also be getting a power of attorney for finances, a really good one. Healthcare power of attorney, guidance to do all this stuff, as well as several ancillary documents. A document that would say what's to be done with your body after you've passed away, HIPAA waivers for your medical information, etc. What does that cost? Depends on whether you're single or whether you are a couple. For a couple to come to us and do this types of planning, I think it's right around $3,000, about $3,000. For a single person, it's around $2,500, I believe, in order to get a comprehensive plan done, specified to you and your situation. All right. How much is it to maintain a trust after setting it up? Well, the minimum is $0. It doesn't cost anything to maintain a trust after setting it up. One thing, though, you have to just be careful is that once it is set up, if you open a new bank account, you have to remember, put it in the trust name. If you buy a new car, remember to put it in the trust name. Excuse me, if you buy a house or any other land, just remember, put it in the trust name. That's all you've got to do. And it doesn't take an attorney to do that. You just have to put the trust name on the title, and that's it. Let's see. Are there good reasons not to set up a revocable trust? Well, that's a very good question. Why would you not want to set up a revocable trust? The one reason that I thought was a good reason, my client several years ago said, I think those trusts are wonderful things, but my family has nobody that's trustworthy. And that's kind of a pun or play on words because trust is used in different ways, but they wanted the court to supervise their family through the probate process because they didn't trust any of their family members. That is a good reason to not use a trust, but use a will instead. Other than that, the cost of setting up a trust is more expensive than setting up a will-based plan. And that's a factor in many people's decisions. So some people have, a lot of people would love to have the Porsche, brand new, race car. But what they do is they get the Volkswagen or they get the Hyundai. Why? Because of the cost, right? So you could have the Hyundai, the will-based plan, and it works fine for you, and it's just a little bit more trouble after you've passed away. But you could always get the nicer plan, the trust-based plan that's going to be nicer on your family after you've passed away. So, are there good reasons not to set up a revocable trust? Cost is one reason that keeps some people from setting up a trust. Is it a good reason? Depends. Depends on what your situation is and really your family situation. Okay. So I think that's the end of the questions. Are there any more questions, Laura? Have you seen anything? Did I get everything? Let's see. I see a new question. If you do a trust, does that replace a will, or does it trust include the will and include healthcare and financial powers of attorney? Well, if you do a trust with us, you would also have the will, the power of attorney, and everything. We would redo everything. So your old will, once you get the new plan signed, you just toss it or shred it, and it would you wouldn't have to worry about it anymore. So it does replace a will, but every plan, even a trust-based plan, should have a will that goes along with it just for a backup. We never do a trust-based plan, without having a will that takes care of any property that's added shortly before death that doesn't get into the trust. Let's see. My husband signed with my daughter for her house. Okay, let's see. Okay. I'm not. Oh, okay. So your daughter bought a house, but the husband signed so that they're both owners on the house. Yeah, we could deal with that situation. I would have to ask why that was. Was it just for financing purposes, or was it to make sure that if the house was sold, that you would get some money back because you put money into it? It really depends on the situation. I would rather not get into that specific situation there. But anytime two people's names are on something, both of them have to worry that the other one is going to die or become ill or go bankrupt or get divorced. When you're worried about two families and all of those things, there's a good chance that something's going to come up that's going to affect that property, and it's not your fault because the other person either got sick or divorced or something. So you got to be careful about putting property into joint names. Trusts are oftentimes a lot safer there, that they won't be affected because of divorce or things like that. But just you should get advice about that specific situation. Okay. So yeah, and it does create a complication. Depending on how many children you have, if your daughter is your only child, it would be less complicated. But if you were giving assets to, say, 2 or 3 children, and then your daughter got the house when you die, are the other children being fairly treated with regards to that? Do you care? These are all things that you would have to consider. Can retirement accounts go into trust? No, until you die. Okay, so retirement accounts, we're talking about formal retirement accounts, not just where you set money aside for your retirement. This is IRAs, 401ks, 403bs, SEPs, all of those things with the alphabet soup of the way that they're named. They're named that way because they fall into a federal category called qualified retirement accounts. Qualified retirement accounts must be in an individual's name. You can't even have husband and wife on those accounts. It's got to be one or the other. And you cannot put them in a trust, or you lose all the benefits. You have to pay all the taxes, and you lose the benefits of having them in that special qualified retirement account. So after you've passed away, you can name a trust to be the beneficiary of those accounts, but there are certain things you have to worry about or could be concerned with when you name a trust as a beneficiary of those accounts. Primarily taxes. Trust tax rates are much higher than individual tax rates, so you have to be careful how you do that. All right, so we are nearing the top of the hour. Thank you for all of your questions. I loved it. Hope you got a little something out of this Estate Planning 101. If you need more information about this stuff, you can go online, check out the book. It really does answer a lot of questions in a fairly simple way that's fairly easily understood. Or give us a call, set up an appointment, and maybe I can answer some of your questions about estate planning. So God bless everyone. Have a great day, and hope to see you again.